Estate planning is not the most cheerful financial planning topic, but any financial plan should include a solid estate plan. Today I'm going to go through 7 common mistakes that I see people make when they do their estate plans. But first, I want to be clear, I'm not an estate planning attorney. I'm not an attorney of any kind. Today really is just to stir thought. You should reach out to a legal professional to draft an estate plan of your own. So the first and most common mistake is an incomplete estate plan. About 68% of Americans die without a will or a valid estate plan. And in those cases, the courts get to decide how the estate is settled based on state law, which is not ideal. Now, even if the state somehow managed to fulfill your wishes exactly, without instructions from you, your estate could become the center of legal action and estrangement among your descendants. The bottom line is the lack of a will or an estate plan could cause chaos for your loved ones. And remember that estate plans don't stop at a will. There's several other documents that most estate plans should include. First, we've already talked about a will, but you could also have a trust. A trust is a legal entity that serves as kind of the legal path for distributing your assets to your heirs according to your wishes. Another important document is a durable power of attorney. A DPA allows an agent to act on your behalf if you're unable to do so for yourself. Having that option could be critical if you become incapacitated or mentally unable to make sound decisions about your finances and your property on your own. Along those lines, a medical power of attorney is also a very important document. It works like a durable power of attorney, but a medical power of attorney allows an agent to make medical decisions on your behalf if you're not able to do so. Next, you should consider an advanced healthcare directive. This document basically allows you to record instructions about how decisions should be made regarding your medical care if you're not able to do so on your own. And normally, an advanced healthcare directive also includes a medical power of attorney and a living will. So you may get multiple documents in one if you have an advanced healthcare directive drafted. Next are beneficiary designations. After your death, your financial custodians will give your assets to the named beneficiaries on your various accounts, and these selections actually supersede other estate documents. I'll address this more in a bit, but it's something to keep in mind. Next is a letter of intent. This is a document that communicates kind of who gets what to your executor. Odds are it won't be legally binding, it usually isn't, but it will make your executor's life much easier as they try to guess how you wanted the silver distributed or that piece of art or this jewelry or whatever. It's for their sake, really. Finally, guardianship. If you haven't already nominated guardians for your minor children, you need to do that somewhere in your estate planning documents. Usually you would cover it in a will or a trust, but if you haven't, make sure you do that because otherwise the courts will do that for you also. Number 2 is an outdated estate plan. If you've had a will or a trust in place for very long, it's highly possible that your preferences toward your heirs or your executor may have changed. There could be loved ones named in your will that have passed away. Maybe your executors moved away and they'd have a difficult time settling your estate. Perhaps your children have gotten married or divorced, or they blessed you with grandchildren and you'd like to consider them in your estate. Laws may have changed since you drafted your estate documents. The value or the nature of the assets in your estate could have changed in such a manner that wasn't foreseeable when you drafted your estate documents in the first place, and you need to change things. There really is an endless number of things that could happen over time. Now, to avoid an unfortunate mishap, it's a good idea to review your estate planning documents at least once a year. It would be a shame for your wishes to go unfulfilled or be delayed when a simple update could take care of it. Number 3 is not having named account beneficiaries. We talked about this briefly in item number 1. I couldn't find any statistics about how often errors are made here, but I do know of cases where people have failed to either name account beneficiaries outright or they forget to keep them up to date. Now, if you have any sort of financial accounts like a savings account, a 401k, or an IRA, you need to name account beneficiaries. As I mentioned previously, these institutions will follow your account beneficiary designations over your will or trust, so it's important that you pay attention to this. If you fail to name a beneficiary, then your assets will probably have to go through probate, which would be a lengthy and expensive process. Also, if you fail to update a beneficiary, you could accidentally leave your assets to someone you didn't mean to. The most salacious example is people who accidentally leave a large retirement account to an ex-spouse instead of the person they were married to at their time of death. Now, in addition to divorce, you may need to update this information if you've had additions or suffered the loss of a child, spouse, or any other family member. I'd recommend that you also add this to your annual estate review process. Mistake number 4 is adding co-owners to assets. Now, there are several things people typically do to try and avoid sending their assets through probate after they pass away. It's completely understandable because the probate process is often lengthy and expensive. Now, one common way people try to do this is by adding loved ones, usually their children, as co-owners of accounts or major assets like a home or a large investing account. Now, unfortunately, this could be a very penny-wise and pound-foolish approach to estate planning because of the potential tax liability it creates for your heirs. You see, when you pass away, many of the assets you leave to your heirs will receive a free step up in the tax basis when they're inherited. As a result, any capital appreciation in the value of the asset will go completely untaxed to your heirs. However, if they co-own the asset, then there's no step up in the tax basis because they were a co-owner before your death. The most common example of this is a house. Now, assume you bought a home many years ago for $100,000, and over the years it has appreciated in value and it's now worth $750,000. Well, if you leave the house to your heirs, they'll receive the full value of the $750,000 home completely tax-free. Even if they decide to keep the house, the basis for future capital gains will be $750,000, not $100,000. But if you put your heirs on the title to the house before you pass away, the tax basis will remain at $100,000 until the last co-owner passes away. So in other words, the decision to add your heirs to the title would have exposed $650,000 in appreciation to capital gains. That's going to be $97,500 if you're in the 15% tax, capital gains tax bracket, or $130,000 if you're in the 20% bracket. So instead of adding beneficiaries to the deed or title of your assets, make the assets transferable upon your death, or look into a trust or a life estate deed. Mistake number 5 is forgetting to fund your trust. Now, speaking of trusts, they are a great way to not only avoid probate, but to also provide very specific directions on how the assets in your estate are managed after your death. Now, a trust is a legal entity that holds assets according to the directions of a grantor. That's the person who creates the trust. And they're managed by a trustee for the benefit of a beneficiary or multiple beneficiaries. The trusts are more complex and more expensive to set up than wills, but as I've already pointed out, they can allow your estate to avoid the probate process altogether. And depending on how complicated you make your trust, it can make the settlement of your estate much easier for your heirs. However, all this planning could be for naught if you fail to fund the trust after it's created. It can be a lot of work to transfer assets into a trust, but your trust won't be much good without this all-important step that a shocking number of people forget to take. On average, it costs a few $1,000s to set up a trust, but can be much more depending on how complicated you want it to be. So for the sake of your heirs, I highly recommend setting up a trust as opposed to allowing your assets to go through probate, which they'll do if you only have a will. Mistake number 6 is unequal tax consequences. So if you have assets with future tax liability that will persist even through your death, you need to keep in mind that they may not be taxed evenly as you leave those assets to your heirs. So for example, let's assume you have a Roth IRA with $100,000 and a traditional IRA with $100,000 when you die. You also have 2 children and you desire for them to inherit equal amounts from your estate. Well, in this scenario, the money in the Roth IRA is far more valuable than the money in the traditional IRA because the Roth doesn't have any future tax liability while the traditional IRA does. The child that inherits the traditional IRA will have to pay income tax on distributions, while the child that gets the Roth IRA gets to keep it all completely tax-free. Now, some other common places for varying tax liability include houses, taxable brokerage accounts, retirement accounts, equity in your business, land or real estate, life insurance proceeds, health savings accounts. These all have issues with taxes even after your death that you need to consider as you put them in your estate. Mistake number 7 is not discussing wishes with your family. Now, honestly, I can think of reasons you may not want to discuss your estate plans with your loved ones, and that's certainly your right. But if you don't think your plans will be very controversial and you think your heirs can maturely handle the conversation, then I encourage you to discuss your plans with your heirs before you pass away. Now first, this may give them peace of mind to know that you have a plan in place anyway, and it can also serve to set expectations so emotions are diffused a bit when it comes time to review your final instructions. Additionally, you should consider including the letter of intent I covered in the very first mistake about not having documents. While it may not be legally binding, it will be a great help to your executor as they attempt to locate all of your assets and to distribute them as you wanted. Finally, be sure to tell your executor where to find your estate plans once you have them in a safe spot. It wouldn't hurt to update your executor on this location every year as you conduct your annual review of your will and your beneficiaries and the other documents we discussed earlier. Okay, so from the start, I acknowledge that estate planning is not a very cheery subject, but it's certainly necessary. I hope the information that you've seen here will help you avoid common pitfalls that so many others fall into. If you want to know more about personal finance topics, please check out our YouTube channel. We've got a lot of playlists there, or check out martinmoney.com. As always, I'm grateful for your time and your interest. God bless and take care.